see you again, Elise. You're welcome.
Oh, nice to see all of you.
Take a minute and remind us again why you want to be a circuit court judge.
I believe that I would be of great service here to the people of the 7th Judicial Circuit. I feel that of the applicants that I am the most balanced in terms of the diversity in my areas of practice. I'm young, I'm energetic, and I want to find ways to make our court system run more efficiently. And I'm just up to the task. I think that truly my demeanor, my temperament, my work ethic, all of those things I believe will make me a great circuit judge.
What sort of things would you do in order to make our system work more efficiently?
You know, it honestly depends on which docket you're placed on, because I don't think that you can handle all cases the same. For example, on the criminal docket, having done both prosecution and defense, I think I have a good ability to triage cases and identify those cases that are deserving of a lot of court time versus those that are not. And so what you have to do is you have to control your docket. You know, when there's a felony driving with license suspended, there aren't a lot of issues. So there's no reason why those cases should be continued 4 and 5 times. You know, cases need to be resolved as quickly as possible, because what happens is it has sort of a mushroom effect. If you don't get rid of the simple ones and then you just keep adding cases, it compounds, and then you find yourself in a situation where you need a quick hearing and you can't schedule it for 3 months out. So I think case triage is very important. On the family law cases, it's the same concept, but a little different. You know, family law has so many different personal issues, and sometimes you know that the attorneys are trying their best to advance the cases, and it's their clients that are the hang-up. And so you really got to get involved in, you know, once you've given what you believe is a fair amount of continuances for a divorce based on the amount of assets that they're distributing, or whether there's children involved, you have to start having those attorneys say, listen, if you can't control your client, you need to have your client show up and let me do my job, because there's no reason why this divorce should take 2 years. They don't have anything. They're paying you way more than they'll ever, you know, distribute to themselves. So that it all honestly comes down to triage, and that requires a judge to be prepared to understand what's on their docket, understand how long it's been there, and put those checks and balances in place. We don't want anybody to feel rushed. We don't want to, you know, we don't want attorneys to feel like they weren't given an opportunity to aggressively and fully advocate. But you have to put an end to it. You know, otherwise we have what we have now, which is just a backlog of cases.
Well, let's do the flip side. What if it's not the client that's causing the issue, but what if it's the attorney that's causing the issue, and the sanctions you're looking at placing on there would be more detrimental to their client than what the attorney's doing? How are you going to handle that?
On a case-by-case basis. I mean, you know, I think maybe I'm naive in the sense that I feel like most of the attorneys that I've practiced with here are very respectful when a judge says, okay, enough is enough, and you need to get it to fruition. So I would hope that I can exercise that type of influence on an attorney. Truth be told, you know, if that's the only way to get it done and advance the case, you have to do what you have to do. And then maybe that attorney will then look, that client will look at the attorney and say, what are you doing? You know, you're putting me at a detriment. Maybe you're not the attorney for me, because now you have me in that position. But you can't just continue to let it, you know, go. I mean, as an attorney that does a large degree of family law, there's been a couple of instances where, you know, I'm literally looking at my colleague going, what are you doing? And the only way to advance it is to follow the appropriate motions, get the appropriate sanctions. And I don't like doing it because it does affect their client versus them, but you have to get the case resolved.
Well, let me flip it around again, because this might be a circuit civil position, and sometimes in a circuit civil docket, you'll get extremely complicated, difficult, big dollar cases involving millions of dollars and multiple attorneys and multiple firms, multiple jurisdictions. And sometimes it bothers me when I hear judges or judicial candidates saying that it's my docket and this is an old case and blah, blah, blah. When the parties are spending lots and lots of money on attorney's fees and they have to be prepared, I mean, isn't there a point at some point that you have to defer to the expertise of the defense attorneys and the plaintiff's attorneys in complicated civil matters and not, isn't it really the parties' court and the parties' case? I mean, isn't there a line there somewhere where the judge has to say, okay, it may be 3 years old, but this is a very difficult matter, and I'm going to defer to the attorneys in their work. I mean, do you understand what I'm saying?
No, I understand.
And I mean, how much ownership does the judge really have over their docket?
I wouldn't call it ownership. I'd call it a responsibility. I mean, you're the facilitator. You control the pace. And while you might defer to an attorney on a particular issue because you believe it's complicated, still, when everything is lined up and someone says, why has this case been pending for 3 years? The judge is responsible for having a reasonable explanation. If the explanation is that it's complicated, that's fine. And for me, there are a few cases, maybe 1% of all the cases that we deal with, that I think may fall in that category. Because most of the time, it's only as complicated as you make it. You know, you look at it and you can really break it down to the very basic elements, and a lot of these lawsuits are the same. Some of them have some complex issues when you're dealing with, business issues and family law, where you're trying to evaluate a business or their stocks or ownership, or, some of those things come up, and it's difficult when they need the appropriate experts to get that information together. But I just find it hard to believe that it takes 3 years, unless it's just something very novel that no one's dealt with before. I don't think I'd be one of those judges, and I've been in front of some of them, that make blanket rules. You're going to get one continuance and that's it, and you're going to go back to trial. I don't think that that's fair, because I think every litigant should have an opportunity to fully litigate their case and present all their issues and not necessarily be under the hammer. But it needs to get done. You can't just let it linger forever. It has to get resolved.
I'll ask another. Which judges, circuit judges, do you admire and why?
It changes all the time. It depends on whether they grant or deny a motion, to be quite frank. I've respected Judge Zambrano for a very long time, probably because when I started with Judge Zambrano prior to being a judge, he was my supervisor at the DeLand State Attorney's Office. And what I admired about him was not just who he was in the office, but who he was outside the office, and how he seemed real balanced and real patient and real hardworking. And I think he's taken those traits that are his, and he's carried them over to the bench. And so I enjoy practicing in front of him, although I haven't for a long time. Now I hear he's back in DeLand in the felony department, so I'll be interested to get a case there and see how that goes. Other than that, off the top of my head, I always had a lot of respect for Judge Grimes, just for his compassion. I liked when a litigant appeared in front of him, and whether they won or lost, they felt heard. And I think that that's important. I think people should have confidence that when they go into the court system, they're going to be dealt with fairly. And I believe that he did that very well.
We were on a trend earlier of asking you hypotheticals, and I have a good one that I want to get out. I understand that family dockets are pretty slow these days. Some of them are slow. And what do you do with a pro se person, and I guess this could be civil as well, who in an evidentiary hearing isn't quite getting out the magic words or hitting the elements they need to do to meet the standard for their petition or to win their motion, and the next hearing time is 6 months down the road? Do you ask them questions to draw out the evidence? Do you tell them that they're missing evidence? Do you deny and point out the flaws? You just blanket deny? Generally, what would your inclination be?
As a general rule, I believe I have an obligation to my client to treat that pro se opponent as their own attorney. I can't.
Oh, sorry, as a judge. You're the
as
same
a
judge,
Oh,
and now
okay.
a person's coming before you, and they're just not quite saying what they need to say to prove it, but you think maybe it's there, they're just not presenting it to the court.
I don't think it's my job to help the pro se litigant, because I'm supposed to be neutral. I would expect the attorney that's on the other side to not be unethical. I mean, that attorney knows what the rules are, and that attorney shouldn't try to take advantage of the pro se person because they don't have a legal background. I've had issues, when I was the attorney and you have the pro se litigant, and I've had judges that stepped in and said, no, what you're trying to say is this. And, I'm not gonna lie to you, it annoyed me because I'm like, well, that's not really fair because you're supposed to be neutral, and it gives my client the feeling that, oh, the judge is already siding with this, this party because they're helping them out. And it just shifts the balance a little bit. And I realize it's a difficult position for a judge to be in, but I still think that you have to apply the laws and you have to maintain what your role is in the courtroom. You're not an advocate for the pro se person.
No.
Anyone else?
I do.
Oh, sorry, go
I
ahead.
do. I thought you were still doing your repost. But anyways, Ms. Washington, what have you done since we've seen you last?
What I've added 2 areas to my practice. I accepted, I was doing part-time guardian ad litem work in Putnam County, and then they asked me to consider full-time contract work in Flagler County. So I've been doing a lot of dependency, and it's interesting because we're trying to make some statutory changes to the adoption clause, private adoption clause in dependency cases. So I was able to write a memorandum that I included, and now we're going to be looking at some legislative changes in Chapter 63 as it relates to dependency actions. I've also added personal injury, which I had stayed away from for a long time because I don't, I tend to get along with a client for about 3 months. So the concept of taking a personal injury case and having them, for 2 years while we're waiting to resolve it always sort of kept me away from personal injury. But I finally did it, and I've been adding that to my practice, and that's been going well. I think what's different about me now from the first time I interviewed is I've become more aware of the changes that I have to make on a personal level to be a judge. I think a lot about not only what you gain, but also what you lose and what the changes are to your life. So I think overall, as a person and as an attorney, I have tried to be conscious that people are always looking. I want to be a person that an attorney can respect as a judge. So I am very careful, more so now, about how I carry myself, how I prepare myself for court proceeding, the conversations that I don't want to be a part of and don't want to be around. I understand that there's some associations that may have to suffer because you never want to give an appearance of impropriety. I've taken from, instead of going to a sports bar to watch LSU play, I watch at home because, so I think that what I'm trying to do is trying to engage in learned behavior, because it's not just about getting the position for me. It's about maintaining the position and maintaining it with dignity and respect, where none of you would ever have to feel like, oh my God, I can't believe we had any part in allowing this person to be on the bench. So I mean, in short, I've just tried to mature. And when I look at myself now, I mean, I would have loved to get the appointment the first time out. But if I'm being honest with myself, I'm a better candidate now than I was then because of all the things that I've had to think about and all the changes that I've had to make.
As an attorney that's had cases that have gone on for 7 to 10 years, what is it about you that would cause you not to want to maintain a relationship with clients for a long period of time?
I say that jokingly, really. What happens, especially in the family law, is it's interesting. I do this little exercise. I have an intake sheet, and it gets all the basic information, but it also asks, what do you expect at the end of this litigation? What do you want? Well, because of the emotional nature of family law, what happens is that changes. That changes depending on whether that person, one spouse gets a new mate, or, it just changes. And so what winds up happening, especially in criminal law, is their expectations change because of emotions. And you're constantly having to say, no, this is the law. You remember we talked about this. And I'm having to show them the paper and say, look, remember, this is what you said you wanted. And it almost feels sometimes like you're fighting your client, not the adverse party, your client. So for me, I feel like the longer those cases drag on, the worse that person becomes because their emotions are going up and down. On the criminal side, I tell people, they come and they sit and talk with me, and I say, look, if the state can prove A, B, and C, here's what you're looking at. Well, do you think you could get me probation? No, I can't get you probation because you have 2 prior sales and you have a trafficking and now you have a trafficking, so this is what you're looking at. And even though I'm telling them that, they say, okay, well, I'm going to hire you, help me, do what you can. 3 months later, when I go back and I say, hey, look, you remember I told you I could get you 3 years? Well, now they're offering 2. It's a one-time thing, you got to take it. Then it's, I thought you were going to get me probation. And it just, the longer the relationship lasts, it becomes more difficult because all of a sudden they lose the clarity that you tried to give them from the beginning. So as a general rule, I just try to resolve people's cases as quickly and as fairly as I can. Now, I've had complicated cases that just took longer, and I'll give them the time that they're due. But those are few and far between. Most of the issues are the same. The faces change, but the issues are the same, the feelings are the same, and you're just trying to help them along.
If you were to be sent back to Tallahassee again, what would you do different? What have you learned, and what would you change, if anything? And
as far as for the interviews, I don't necessarily feel like I didn't get the appointments because of anything that I did wrong in the interviews. So I don't know that I would change my preparation strategy. I just tried to be as well versed as I could in current law, and I think about my ideology a lot, trying to prepare for the questions that they brought. Hopefully what they will see in me and that they have seen in me each time is a maturity and a growth, because I think that would be evident to them. But other than that, no. There's a new AG now, so I got to do a little research on him if I get that far and figure out maybe what he likes. I really enjoyed Mr. Antonacci. He was very to the point, which is refreshing. And I actually had an opportunity to talk to him a little bit after the last interviews, and he was gracious enough to offer me some critique that was very encouraging for me. So I don't necessarily think it was something wrong. Governor Scott is in a very difficult position. He gets a slate with 6 or more very qualified people that he doesn't personally know, and he's having to rely on other people to make a decision. And it's difficult. I didn't get the other appointments, not because I wasn't qualified. I just didn't get picked because that's not the way his pendulum, swung at that point.
Bush, thank you. Thanks for coming in.
Thank you.
And we will be letting you know by the end of today's day.
Okay.
Okay?
Yes, sir. Thank you. Have a good day.
You too.